Hello, I'm Jodi Ginsberg of Ginsberg Law Offices. Today I want to tell you about a case that recently came out that limits the rights of attorneys talking with your physicians, and that usually would occur before a deposition would be taking place. In some instances it might occur by telephone. What would typically happen is, in many cases, the insurance defense attorney, or in some cases the claimant's attorney, would set up a doctor's deposition to get more medical evidence on a particular case, meaning that they would want the doctor to elaborate on a particular causation issue as to why this person's back is now as problematic as it is. Is it all related to the work injury? Of course, the insurance defense attorneys would try to come up with any reason that it wasn't. Or they might want to find out what future medical care this person is going to need, something more that they would need from the doctor that was just in the medical records that would be sent as ordinary type in procedure in the case. So what would happen is the attorney who was scheduling that doctor's deposition would show up early than the deposition was scheduled and sit with the doctor for 30 minutes, 15 minutes, whatever the case may be, and talk to the doctor. Now, one would hope that they would just have a legitimate conversation, the lawyer and the doctor, about that particular person's medical situation. However, it doesn't take a lot to realize that what the lawyer would try to be doing would be to persuade the doctor to give testimony that would help that particular lawyer's position in the case, whether it be the claimant's lawyer or the insurance defense attorney. And so what's happened now is the judges have come down, the court has come down and said lawyers cannot have what's called ex parte communications with the doctor. That means the only time you can speak to the doctor directly would be during the deposition when the other attorney is present. Or if everybody agrees that a conference call would be sufficient, meaning lawyer representing the claimant, lawyer representing the insurance company, and the doctor schedule a conference call if they choose to do that. But obviously, for any reason that there would need to be evidence, it would have to be taken down in a deposition where a doctor is put under oath, both lawyers are present, and question and answers go back and forth down the road that is typically used for evidence in a potential hearing that might be coming up in front of the court. So at this point in time, what we're seeing is no communication between lawyers and doctors in an ex parte way, meaning without both being present. And my particular way of dealing with doctors has always been, while I may take their deposition at some point in time, I would typically send them questions to answer. That means I wasn't breathing down their neck to answer a question one way or the other. I simply wanted a legitimate answer. That is, in my opinion, a very proper way to do things. Judges appreciate it, and for the last 2.5 decades, that's how I've done my work, and I think it has been well received when I place those types of answers into evidence, that the judges realize it's proper, it's above board, and that's the way the case should run. In addition, we're able to ask the doctor questions in a deposition, and we're able to be very thoughtful in the way we present questions, in most cases helping our client's case take it to be able to persuade a judge or that indeed the injury is legitimate, or indeed the causation was because of the injury, or that my client needs a particular type of treatment that the insurance company may be pushing back against. So please be mindful of this new case law that's come down, and if you have questions about what goes on in a workers' comp case, how we deal with medical evidence, how we deal with the doctors, you're welcome to call me, and I'm happy to speak with you about it. And you can reach me at 770-351-0801.